Good morning. I think we are now live. And if we are, I want to thank everyone who has joined this teleconference press conference today. I especially want to thank my colleagues, our three city attorneys who are on this call, and more importantly, are part of this action that we're announcing today. Let me announce them in the order that we will be speaking after I make my remarks. I will then turn over the microphone to our city attorney from Los Angeles, Mike Feuer. Mr. Feuer will then do us a favor of, after his remarks, handing the microphone over to Mara Elliott, the city attorney of San Diego. And from there, city attorney Elliott will hand over the microphone to our cleanup hitter, our city attorney of San Francisco, Dennis Herrera. And from there, we'll take any questions you might have. We all have some of our staff who is here, part of our team, available, and we can make them available as well to answer any technical questions about the actions that we're taking today. But otherwise, let me begin first by saying that in California, those who drive for Uber and Lyft like basic worker protections, from paid sick leave to the right to overtime pay. Uber and Lyft both claim that their drivers aren't engaged in the company's core mission and cannot therefore qualify for benefits. We say otherwise. Sometimes it takes a pandemic to shake us into realizing what that really means and who suffers the consequences of it. If drivers in California contract coronavirus, or if they lose their job as a result, guess what? They're the ones that go missing. They're the ones that don't know what to do next. They're the ones who have to worry about how they'll pay their bills, what they'll do in the future, how they'll survive moving forward economically. But it's not just those workers who lose here in California. American taxpayers, California taxpayers, end up having to help carry the load that Uber and Lyft don't want to accept. These companies are willing to take these workers' labor as drivers, but they don't want to accept the worker protections that should go with that work as these employees should get. California has workplace rules that protect all who abide by them. And through our action today that we are announcing in this lawsuit, we want to make sure that Uber and Lyft play by the same rules. Independent contractors have certain categories into which they fall, employees as well. We believe that the law is clear in California. AB 5, which passed last year, made it even clearer based on a Supreme Court decision rendered by our California Supreme Court in Dynamex. And so we are moving forward with this action. What's interesting is that jobless claims in our state are skyrocketing during this COVID-19 pandemic. And it's those vulnerable Uber and Lyft drivers who are the real losers in this whole process. And that's become very apparent. With these companies denying that their drivers are entitled to state unemployment insurance, as well as state mandated paid sick leave and other employee benefits, they're the losers. The companies, we believe, and we argue, are shirking their obligations to their workforce, and they're shifting the burdens onto their very drivers and to taxpayers at a time when these are the most vulnerable. Our lawsuit that we are filing today together asserts that Uber and Lyft gain an unfair and unlawful competitive advantage by inappropriately classifying massive numbers of California drivers as independent contractors. As a result, the companies each avoid hundreds of millions of dollars in social safety net obligations. They get to skip out on contributing to state payroll taxes that are used to fund general health and well-being programs that benefit all Californians. And the lawsuit seeks $2,500 in penalties for each violation of the California unfair competition law and up to $2,500 for violations perpetrated against those Californians, including seniors and individuals with disabilities. We believe it's time for all workers to be treated fairly. We believe that if you play by the rules, everyone goes ahead. We believe that innovation doesn't require you to mistreat workers. And we believe that the law is very clear and it's time to take action. So with that, let me now turn to my colleague in Los Angeles, City Attorney Mike Feuer.
Thank you very much, Attorney General Becerra. Thank you for your collaboration and for your leadership. What is misclassification? It's cheating at the expense of workers and at the expense of our taxpayers. Enough is enough. California law makes it clear that Uber and Lyft drivers are employees. Yet we allege that Uber and Lyft insist on defying this mandate. We allege they're exploiting their drivers. We allege they're unlawfully shifting the costs of their responsibilities as employers to California taxpayers. As law enforcement leaders across the state, we're going to aggressively fight to protect these hardworking drivers, to protect California taxpayers, and we're going to fight to uphold California's worker classification laws. Now, here in Los Angeles, we have a big stake in the outcome of this case. We have anywhere from 100,000 to 250,000 Uber and Lyft drivers right here. In the lead in fighting for worker rights, whether it be car wash workers or home health care workers or port truck drivers, and now rideshare drivers. Society only really works well when our workers can pay their rent, can pay for food, can pay their bills, and can take time off when they're sick. But these drivers haven't had those benefits. These drivers haven't been paid, we allege in this lawsuit, for all the work that they perform, for overtime. They haven't gotten business expenses. They don't have the benefit of unemployment insurance or disability insurance or workers' compensation. That leaves local taxpayers here and throughout the state to pick up the tab. And this lawsuit seeks to change that. So what are Uber and Lyft likely to say when we respond to this lawsuit? Well, they're probably going to say they're just tech companies. But the truth is they exercise nearly complete control over their drivers, from the setting and collecting of fares to deciding the routes to deciding which driver by algorithm goes to which passenger. They're going to say that in this crisis, they've been performing, Uber and Lyft, important roles throughout California. So let's be clear about who's performing those roles. In this crisis, there's no question that the drivers for Uber and Lyft are exposing themselves to great risk as they transport first responders and essential workers and family members to grocery stores or to get medicine, as they take people to visit their senior citizen loved ones. Those workers deserve the minimum protections of California law that employees receive. Because in the meantime, Uber and Lyft, as companies, aren't paying for unemployment, aren't paying for health care. They're making those costs be borne by taxpayers. We need to do better. That's what the law requires. Uber and Lyft are going to say that the drivers like the flexibility of the system that exists now, but creating a false dichotomy. There is nothing mutually exclusive about having workers have flexibility and at the same time assuring that they receive the employee protections they deserve. So at the end of the day, what do we want from this lawsuit? We want to assure that Uber and Lyft play by the rules. We want an injunction that requires it. We want to be sure that their drivers receive full restitution that they deserve. And we want to be sure that Uber and Lyft accept accountability, responsibility for their actions by paying civil penalties. I'm going to say a few words in Spanish, and then I'm going to introduce our colleague, Mara Elliott, in San Diego. Suficiente es suficiente. La ley de California deja en claro que los conductores de Uber y Lyft son empleados. Sin embargo, alegamos que Uber y Lyft insisten en desafiar este mandato, explotando a sus conductores y trasladando ilegalmente los costos de sus responsabilidades como empleadores a los contribuyentes de California. Como líderes policiales en todo el estado, vamos a proteger agresivamente a estos conductores que trabajan muy duro y luchar para mantener las leyes de clasificación de trabajadores en California. Mi oficina ha estado defendiendo a muchos tipos diferentes de trabajadores, incluidos los que trabajan para el lavado de autos, la atención médica y domicilio, y las compañías portuarias de camiones. Estamos buscando que Uber y Lyft clasifique adecuadamente a estos conductores como empleados, proporcionarles y ser responsables pagando sanciones civiles. And now it's my pleasure to introduce our colleague, Mara Elliott, the very distinguished and extraordinary city attorney of San Diego, a real friend and a great colleague. Mara, you're up.
Thank you, City Attorney Fuhr. I'm pleased to be here today with my fellow city attorneys and the California Attorney General, fighting for the rights of workers to fair pay, fair treatment under the law. This lawsuit is very important to our drivers here in San Diego. Our economy is built on tourism, yet our streets are empty and our tourist attractions are like ghost towns. Events like Comic-Con, our beloved county fair, and the Kaboo Festival have all been canceled. The lack of work has placed great stress on our drivers and on their families. The income they hope to make this summer has all but dried up. Some drivers are making ends meet by delivering meals and groceries without basic safeguards like masks, sanitizers, or gloves. They do this to survive and are among our most vulnerable workers. Now, when they need unemployment insurance the most, they're shut out because Uber and Lyft are thumbing their noses at the California legislature and the public officials charged with enforcing these laws. Uber and Lyft are billion-dollar companies that refuse to follow the rules, expecting taxpayers to pick up the slack when their employees get sick, need a hospital, or lose a job. Enough. It's time for Uber and Lyft to respect the law, their employees, and taxpayers, and it's time for them to pay their own bills. It is my great honor to now introduce to you San Francisco City Attorney Dennis Herrera.
Thank you, Mara. First, I'd like to thank the Attorney General for his leadership in bringing us all together today to announce what is truly an unprecedented partnership to protect workers' rights throughout the state of California. And to be joined here by my colleague, Fuhr from Los Angeles, Mara Elliott from San Diego is a true honor. As they have stated, why we're all here today is that we have a clear case of Uber and Lyft knowingly and illegally misclassifying their drivers as independent contractors for virtually the entirety of their time in business. And that is all done at the expense not just of their worker drivers, but at the expense of California taxpayers who are left to pick up the tab for the services that they are unwilling to pay for. And that's why you see this unprecedented partnership led by our Attorney General and joined by my colleagues in two of the cities, the state's largest cities. As they have laid out in great detail, from unemployment insurance to workers' comp to healthcare, Uber and Lyft have been shifting their responsibility for paying for their worker drivers to California taxpayers. That's one thing to happen in good times, but it's even more drastic when we see it happen in economically trying times that we are undergoing now. As my colleague from Los Angeles talked about, what are you going to hear Uber and Lyft say in response to our lawsuit? They're going to talk about the loss of worker flexibility. Nothing could be further from the truth. That is a lie that has been sold to their drivers and to the California public in an effort to avoid their responsibility under the law, as made clear by our California Supreme Court. The fact of the matter is that Uber and Lyft have shifted the burden of virtually all the expenses of their business onto their driver workers. And what has that done? It has essentially made drivers treat their employer as mobile payday lenders by failing to upkeep their car and pay expenses so that they can raise their wages above a minimum wage standard. That's something that those of us in San Francisco are particularly attuned to. We have a history in San Francisco, the headquarters city for both Uber and Lyft, of being generous when it comes to providing for a social safety net for our residents. Uber and Lyft estimate that drivers drive approximately 20 miles. Our stats show that they drive virtually 20 miles every hour. Thus, 31 million miles of drive miles here in San Francisco translates to virtually $4.5 million in healthcare expenditures that they would be forced to pay under our city's healthcare safety ordinance if they lived up to their obligation, which they are not doing now. The fact of the matter is, we know that this is being done for one reason and one reason only, is pure profit. And that is why you have seen both Uber and Lyft, when AB5 was going through the legislature, seeking an exemption to make sure that they continue their business model, which exploits workers and hurts taxpayers. And they have already made quite clear that in the face of not getting that exemption, they're going to go to the ballot and spend tens of millions of dollars to overturn the will of the California legislature and to shirk the responsibilities that have been laid out clearly in the Dynamex case that was decided at the California Supreme Court. The time for the rapacious conduct is at an end, and it's time that Uber and Lyft live up to their responsibilities, both to their driver workers and to California taxpayers. Thanks very much, and with that, I'd like to hand it back to Attorney General Becerra.
City Attorney Herrera and to all my colleagues, thanks very much.